Welcome back. Senior Advocate of Nigeria, Dele Adesina, is my guest on the program today. He has practiced law for about 30 years, during which he has held many leadership positions. He was elevated to the rank of Senior Advocate of Nigeria in 2007. In this interview, we talk about the anti-graft war and the role of lawyers. Retired judge of the International Court of Justice, Prince Bola Ajibola, SAN, recently advised the NBA, and by extension senior lawyers especially, not to hinder the ongoing anti-corruption fight of the federal government. He said if they did not want to be seen as aiding corrupt people to evade justice. Would you say that this advice is justified?
Prince Bola Ajibola is a highly respected member of the legal profession, a past president of the association. And I would say, just like anyone will say that words of our elders are words of wisdom. It's a good counsel, and it's a welcoming advice. The truth is that whether you are a senior or junior member of the legal profession, you cannot hinder. Because there is nobody in Nigeria today who doesn't know that the bane of our problem as a nation is corruption. It's a cankerworm. And I think some of us have delivered several papers on it, calling the attention of the powers that be to the need to address the problem. I've had to deliver 2 papers at the Institute of Security Studies on the issue of corruption and the consequences it has unleashed on the nation. You know. So, like I said, it's a welcome advice. You get my point. But whether a senior member of the bar or a junior member of the bar, nobody should do anything that can hinder the prosecution or the war against corruption in Nigeria.
But why do you think the judiciary and lawyers are getting regularly bashed for aiding corruption?
You see, I get worried at the trend, and I believe any individual should be worried. Not just the senior members of the bar today. The juniors of today will be seniors tomorrow. We are the senior members of the day for this time. In the past, we were junior members. Life is in phases, and everybody lives his own phase and leaves the stage. You get my point? Maybe because senior members get briefed to handle some of the defenses in these matters. But I'm also privileged to know that senior members do get briefed from the investigating agencies, particularly the FCC or ICPC, to prosecute. I once belonged to a team of 9 senior advocates of Nigeria put together by the EFCC to prosecute the corruption cases and financial, do I say improprieties, by some bank executives in 2008. So senior members are here for both the defense and the prosecution. And that is in discharge of their statutory and professional responsibilities. You get my point? You must know that anybody who is facing a criminal matter, who is being charged for a criminal offense in a court of law, his entire life is on that case. If he fails, he goes down, and possibly generations after him in his line. Nobody will be proud to say, my name is Mr. So-so-so-so, the son of Mr. So-so-so or Chief So-so-so, who was once convicted of crime at so-so and so time. Nobody will say that. So if you have the means and you are face to face with what is capable of destroying not only you but also your lineage, you have to put in the very best that you have. And the Constitution itself, Section 36 of the Constitution, and so many provisions in that section from sub 1 to sub 12 emphasize the significance of fair hearing. It even specifically stated that every person charged for any offense is presumed to be innocent until his guilt is established.
One of the allegations against senior lawyers is that they aid accused persons. They even coach them so that they can get off lightly.
One can appreciate the apprehension of the society that we are in today. The desire to stamp out corruption and financial crimes should be the desire of everybody. So if the results are not coming in as quick as we wanted, it is normal for people to be raising this kind of questions. But I'm unable to believe that a counsel engaged to defend an accused person will sit down and tell him, this is what you should do, this is what you should not do, this is the lie you should tell, this is the lie you must not tell. The code of conduct of our practice stipulates very categorically that a defense counsel must not urge a defense he does not believe in on the court. Not only that, a defense counsel must never mislead the court. When you lie to the court, you are misleading the court, and you can be sanctioned for it. And in this process, it is neither because you are a senior or because you are a junior. Those who mislead the court and getting away with it, I will put the blame squarely, at the courts. I was telling somebody yesterday, at a private discussion, I said, when we entered into this profession some 34 years ago, the law of content, either in the face of the court or outside the court, was very potent. The system provides for this law, that when you see a lawyer, committing any infraction against his professional responsibility or against the code of conduct, the ethics of the profession, he's supposed to be sanctioned. And when it is done right in the face of the court, the presiding justice or judge, if it is a high court, can ask him to step out of the bar and is ordered to remove his wig and gown and summarily dealt with there and then. We don't see those things anymore. I believe there has been permissiveness and impunity, These are some of the reasons that have given birth to that level of impunity. The time, I believe, has come to preserve the system. I keep saying that the system must be preserved. What do I mean by the system? I mean the institution. The judiciary is an institution that has no option in any nation. The only option to judicial proceedings or adjudication before a court of law is anarchy. And nobody wants anarchy. So it is in the interest of the lawyer and the interest of the judiciary that people continue to sustain confidence and trust in the institution. So those coercive powers of the days of old that made people to respect the judiciary are still there. But we are no longer using them. The question is why? Whether you are a junior or you are a senior member of the bar, nobody has a room to behave anyhow. It's a well-regulated profession. Highly regulated. Apart from the Legal Practitioners Act, there is the ethics of the profession. There is even in the making a code of conduct, even for senior advocates of Nigeria. The members of the public are not aware of this. Right from time, we do know that we constitute, not at all. That has been on. For example, about 2 years ago, the body set up a committee to do this. And the code includes even your appearance. Because as a leader, you must demonstrate the highest level of responsibility. Leadership is responsibility. It's not for fun.
Now, I know that in defense of the judiciary, some people have accused the other two arms of government of treating them unfairly. And most people refer to the fact that federal judges especially, last time we checked, have not been paid their salaries this year. Do you think that situations like this open up the judges to temptation?
Let me answer that question by recalling a specific statement made by a retired chief judge of one of the states around 1998. I I was the chairman of my branch at that time. And at a public function, the CJ said that we're talking about corruption in the judiciary. There is no cause without an effect. What is responsible? Why not justifying that it is the salary that is making judges to be corrupt, but he said that the salary of our judges constitutes, an incentive to corruption. He made that statement. And it gladdens my heart to note that after that statement was made, the bar in Lagos State took it as a responsibility. Every available opportunity, we were making a case for better condition of service for our judges. The second situation I would like to recall, which has direct bearing on what we are saying. Before in Lagos State, our judges were either living in GRA Ikeja or living in Ikoyi when they were in service. And after service, it's either they go and live in Agege or to go and live in Mushin, Imagine somebody who had once convicted, you get my point. We saw that also as unacceptable. So if you see somebody who really does not have the fear of God, don't forget, opportunity makes the thief. I am not saying they have to be corrupt so that they can prepare for their after-retirement period, but he is a human being. So, like I said earlier, the Lagos State acceded to the request. And today, every single judge in Lagos State occupies his own house, living in his own house, in high-brow locations of Lagos State. They don't need to retire and go to Mushin or go to Agege or go to some other hidden places. And we have also taken this to higher level. Okay. There is no reason why it cannot be replicated. I know of a justice of the Supreme Court who was living in Maitama when he was serving at the Supreme Court. And today, I cannot even pronounce the area he's living in, outskirts Abuja. So, investment in the judiciary is an investment in the rule of law. An investment in the rule of law is an investment in democracy.
The duty of lawyers is to always satisfy the standard of the legal profession. A lawyer must not make a defense he or she does not believe in, as legal practitioners must always be ministers in the temple of justice. The courts must also be proactive and discipline lawyers who commit infractions against the ethics of the profession. These are just a few thoughts from my guest, Mr. Dele Adesina, SAN. As always, you can share your thoughts, comments, and questions using any of our social media handles. If you missed any part of this program, you can find it in past episodes on our YouTube channel. I am Shala Sheyeli. Thank you for watching.